class. This is my third presentation for legal ethics, and our assignment was to draft a retainer and fee agreement. And Ms. Johnson gave us a case that's loosely based on a real-life case, but I want to disclose this. I have changed the names and the address and left out a lot of the actual circumstances to protect the identities of the real people. She gave us the fictional Addy and Barrister, PLLC, the law firm that we work for. Our victim's name is Valerie Victim, and she will be the plaintiff in our case. And the defendant, the one that we're going to sue, her name is Tammy Tortfeasor. So we're suing Tammy Tortfeasor for civil assault and battery. Okay, and I'm going to walk step by step on my draft. So in the top here says Addy and Barrister, PLLC. That's supposed to be our letterhead for our law firm. And then this first sentence, I have Barry Barrister, attorney for Addy and Barrister, PLLC, and Valerie Victim hereby agree that he will provide legal services to Ms. Victim on the terms set forth below. Paragraph 1 is titled Conditions. In this paragraph, I'm just saying that if she doesn't sign this and doesn't agree to it, then the deal is off, basically. Okay. Paragraph 2 is titled Scope and Duties. And here we're just saying that our job, Barry Barrister and his legal team, is to file a lawsuit for civil assault and battery, and that's it. Nothing more and nothing else. So let's say that Miss Victim is not happy with the outcome of the case and she wants to appeal, or she wants to sue for something else, or whatever, then Barry Barrister is under no obligation to go along with it. You know, he could say find a different lawyer or whatever, but he is not required to appeal it. He might even, agree to it, but a separate contract has to be made, new fees, new expenses, all of that. Okay, next we have paragraph 3 called Legal Fees. And here it says that Ms. Victim is agreeing to what is called a contingency fee of 30%. So this is kind of unusual because we're not demanding an upfront fee. We're not demanding any sort of down payment. We're saying that if she wins the case and she gets monetary relief, then we want 30% of that. If she doesn't win the case, then we don't get anything. This is lawful, and I will show you in the American Bar Association ethical rules. You can find this in Rule 1.5, titled Fees, Section A8. And it says whether the fee is fixed or contingent, just saying that contingency fees are allowed, they're fine. Also in Rule 1.5C, it goes more in detail about contingent fees, and it just says a fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D. I'm going to jump down to paragraph D and read the prohibitions just to make sure that we're okay. And it says that a lawyer shall not enter into an arrangement for, charge, or collect any fee in a domestic relations matter. So we're good. This is not a domestic relations matter. A contingent fee for representing a defendant in a criminal case. This is a civil case, not a criminal case, so we're good. And that's it. Okay. Next we have paragraph 4, costs and expenses. So in addition to the 30% that we require, we also need to be reimbursed for any extra expenses or costs that are incurred. So that could range from postage to parking to long-distance telephone calls to expert witnesses. And I doubt it'll come to expert witnesses, but just in case, we have that in there. And what we're saying is we need to be reimbursed for all these extra costs. So what will happen, let's say that Ms. Victim is awarded by the court $100,000. First, we're going to take out the money, we're going to deduct the money for the costs and expenses that were incurred. And then after that, we're going to take out 30%, and that'll go to us, the lawyer, the legal team. And the rest is going to go to her. In Rule 1.5, Section B, it says that the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing. So we're letting her we're letting her know up front that there are going to be some extra costs and expenses, and yeah, we have it in writing and everything. Paragraph 5 is titled Statements, and I wanted to be extra careful, so I threw this paragraph in there, and I'm saying that we are going to let her know. We're going to give her periodic records of fees and costs, and she will be kept informed throughout the entire legal process. She will not be surprised or shocked or whatever whenever the case is over with and we are taking out these deductions. So she's going to know all about it. You can find this one, Rule 1.5a, where it says that a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. Okay? Next we have paragraph 6, called Discharge and Withdrawal. Ms. Victim may discharge Mr. Barrister at any time. So if she feels that his services are no longer required, she's allowed to terminate. And if he feels that she's being unlawful or unethical or uncooperative, he can also terminate. Paragraph 7 says conclusion of services. This is just saying that once Mr. Barrister's services conclude, all unpaid charges shall become immediately due and payable. And he is going to give her file if she wants it, yada yada. Paragraph 8, the last paragraph, is called Disclaimer of Guarantee. And this is saying that Mr. Barrister and his law firm are not going to tell her that she's going to win this case, because we don't know. We don't know what's going to happen. We are making no such promise or guarantee, and she cannot hold it against us if the court does not find in her favor. And then all she has to do is write her name, date it, and sign it. And that is it. That is the end of my presentation. Thank y'all for watching.